Sometimes even the best of practitioners can find themselves stepping on ethically perilous ground. Gerard Mullins, KC, remains a respected, decorated member of the senior bar in Queensland. In the mid-2000s, however, there was a misstep. He was representing a Mr. White in a personal injuries matter. Mr. White had become a quadriplegic as a result of a motor vehicle accident. The barrister, Mullins, was negotiating with Suncorp insurers and their lawyer, Mr. Kent, about the amount of compensation that Mr. White should receive. Calculating that compensation is complicated, and part of it involves estimating the future economic needs of the plaintiff, depending on their expected lifespan, taking into account their injuries. A specialist firm called Evidex provided an expert report to that effect, and a mediation date was set. Mr. White then received awful news. Not only was he quadriplegic, but his doctors had discovered extensive secondary cancer, and they couldn't even find the primary cancer. The result was that his expected lifespan was now much shorter. The question facing Mullins, the barrister, was whether he was required to disclose the cancer diagnosis to the other side. Inevitably, if he did, the other side would substantially reduce their settlement figure to reflect Mr. White's diminished lifespan. Mr. White, of course, preferred not to disclose. Mr. Mullins consulted with other barristers, but he seems to have approached the matter as a question of evidence rather than as a question of ethics. It all eventually came to light, and the Legal Services Commission took action against Mr. Mullins for breaching the barristers' rules requiring candour or honesty, including in settlement negotiations. The court said when this mediation was held, Queensland barristers could not have approached the exercise on the basis that they were entering an honesty-free zone. By continuing to call the Evidex reports in aid as information supporting Mr. White's claim, after learning the cancer facts and recognising their significance for the validity of the life expectancy assumption, the respondent intentionally deceived Mr. Kent and Suncorp representatives about the accuracy of the assumption. He did so intending that Mr. Kent and Suncorp would be influenced by the discredited assumption to compromise the claim, which happened. Mr. Mullins was fined and reprimanded, but has continued his service as an officer of the court. From this case, we learn that even in settlement negotiations, a practitioner cannot lie or mislead.